5555. Call us back. This is Your Business Matters with Pallavi Aluwalia from Aluwalia Law Offices. Going to our next caller, Phanisha Radio. You are live on the air. Please go ahead and ask your question.
Hey, hi. Into I-140.
All right, go ahead, please.
Sometime back, 2 years back, I think there was a proposal that I think that wasn't passed through, but it goes like this, right? So if your I-140 is approved and if you stay with the same company for 6 more months and your I-140 is not going to be revoked, right? Cannot be revoked.
Correct. So this is a proposed rule. This was announced in the end of December. The comments on that were due end of February, beginning of March. And since then, it's still waiting its final shape and form, which has still not been announced. So it will come out in the Federal Register, but it is still not the rule. Yes, that is a proposal that is still underway.
Okay. So let me ask you this way. So is there any requirement to stay with the same company for some time right after your I-140 approval? Or is it a good idea to stay with the same company right after your I-140 approval?
Yeah, so if you want, number one, if you want your priority date to be retained, and at this point I'll tell you every month, every week will count, because look at the queues and how backed up they are. So people, that just kind of miss the boat by a week or two also. Sometimes will get harmed with the retrogression that we see across the board in EB2 and EB3. So it's important that you retain that date, and for that, currently the rule of thumb is that the government on a discretionary basis will give you the I-140 priority date when you apply for it again, based on how long you were with your previous company. However, what they're trying to formalize is a 6-month rule, so I would not suggest moving anyway before the 6 months are over, 180 days are over, but I would suggest, yes, if you were to be with an employer, unless there is a drastic change in circumstances, I would say hang on there. Otherwise, you're just going to be moving around and starting out the whole process over and over again.
Okay, so it's good to stay with the same company that you...
I would suggest that, unless you're having issues, meaning that anybody can have. Otherwise, I would say just hang in there, because it doesn't make sense for you to move. And then at this point, there is no rule for 6 months. This time it is at the discretion of the government, and you don't want to challenge that.
Okay, that's good to hear. I just got a new opportunity, good opportunity, so I was thinking about this.
And that may be the change in circumstance. And if it's been under 6 months, I won't do it. But if it is that it's been over 6 months, but you've had a bona fide stay with this employer, it should be okay. So, and it's a call that you'll have to make.
Sure, yeah, that's good. But there is no hard limit on the 6-month thing, right? It's good to have 6 months period at least.
Yeah, at least go past the 6 months. Greatly past the 6 months if you want the discretion in your favor.
Yeah, sure. Thank you. That's all I have.
Okay,
Thanks.
all the best to you. All right, thank you so much for your call, and to all our callers right now who have legal question to ask, do remember that Pallavi will be here after the 11 o'clock break. So yes, hang in there with the number in the studio and your question. 972-235-5555 number in the studio. Going to our next caller, Phanisha Radio, you're live on the air. Please go ahead and ask your question.
Good morning, Ms. Pallavi. I have a question regarding the siblings sponsorship. What is the difference in there when you see visa bulletin? One is saying for India is December 1st for October 2002, I think 2001 or 2002. But when you scroll it down, the same information page, it says May 1st, 2004.
Yeah, so those are the ones. So there are 2 dates, you're right, and that has caused a lot of confusion, but this has been going on for the last 8 months because they changed this process. The final action dates are the people that are now getting their green cards. And the other date that you see there, which is dates for filing family-sponsored visa application, the B chart, that involves the time that the NVC will reach out for information, have you complete the forms if the people are in the country, in some other legal status, then they can apply for an adjustment of status. So that is just a chart that is an advisory chart that the Department of State says the NVC will start off the process of collecting the DS forms, the affidavit of support and all of that, as well as if the people are in the country, they can do the AOS.
So if somebody's in Delhi, what date we consider?
This will now just depend on whether NVC, it would be the second date that it's not a consideration, it is a start of the process that would wrap up. They will not get the green card till it shows up in the final action date. This is just the beginning of the start of the paperwork that will take them to the green card, which will only be given once that date shows up in the final action.
The visa will be priority, will be current. Okay.
Correct.
That's it. Thank you very much.
All the best to you.
Thank you so much for your call, and we have under a minute left, and I don't think we should take a call right now, but do want to let you all know that Pallavi will be here for a little longer time, so stay around and keep calling us. Right after the break, we will take your calls on air once again with Pallavi. Pallavi, is there a quick update that you can give us? We have exactly like 40 seconds.
Yes, this is the new change in the N400 form, which there is an updated form. Has to be the new form that has to be used from December 1st onwards. No pictures that are going to be required. Biographics will be taken at the application support center. So that's a quick update right there.
All right. Thank you so much. And once again, 972-235-5555 number in the studio. This is Your Business Matters with Pallavi Ahluwalia from Ahluwalia Law Offices, and ahluwalialaw.com is the website which shares all the information about their office, and also you can find the recorded program, the show that we do here on the airwaves of Anisha Radio 104.9 FM in the archives of ahluwalialaw.com. Keep listening.
With your questions at 972-235-5555. That's 972-235-5555. Or email pallavi@yourdesilawyer.com. Call now to get a second opinion on your current case. Miss Ahluwalia received her law degree over 18 years ago, and her office handles cases involving immigration law, family law, business law, contract law, and civil litigation. Call 972-235-5555. That's 972-235-5555. Or email pallavi@yourdesilawyer.com. Questions for the program Your Business Matters with Pallavi Ahluwalia can be in English, Hindi, or Urdu. If you prefer an in-person consultation, call 972-361-0606. Remember to turn off your radio when calling. This has been...
That's right. Remember to turn off your radio before you ask your question. And we would love to continue the segment here, the legal segment. The calls coming in, 972-235-5555. Once again, this is Your Business Matters with Pallavi Ahluwalia from Ahluwalia Law Offices. Any questions that you have in regards of family-based immigration matter, family law, corporate law, civil matters, or anything that comes in your mind about employment immigration matters, well, do let us know. 972-235-5555. Pallavi is here to help you with those. And once again, do want to welcome on the airwaves of Anisha Radio 104.9 FM. It's Pallavi Ahluwalia from Ahluwalia Law Offices. And it's always good to have you in the studio. I love talking to you.
Okay, thank you. Thank you, Vito. Pleasure is mine. And let's start taking our callers. I know they've been very patiently waiting for us. And thank you for your patience. Let's just start taking the calls.
Let's do it. Going to our next caller, Anisha Radio. You're live on the air. Go ahead and ask your question to Pallavi, please.
Yes, please.
All right. I think the call just got dropped. Please call us back. 972-235-5555. Number in the studio. You're live on the air. Go ahead and ask your question, please.
Hey, Pallavi. I applied for green card last December, and I got my I-140 approved in May. I traveled India and entered US in parole in August. So I want to know whether this parole entry will get my green card delayed for any reason.
No. It should not. So parole is something that you've been paroled into the country and that used it for the purposes. Could you just turn down the radio? Sorry, because I can hear the echo. So you'll have to use your parole for the travel purpose, but you can continue to use, if you have an underlying H1B, you can continue to use that for work purposes. Okay, the government does allow that. Just entering on parole should not delay anything. Your green card or when it comes through is going to depend on the priority dates and all of that, and that's the only
I was
reason.
in EB1C. I applied in EB1C, and the processing time shows like it's already processed till February 2017. So, I have booked my InfoPass appointment to check what is the status.
So
any guidance like what I should check with them?
So just a quick question. You do have your I-140 approved, you said?
Yeah, I have my I-140 approved.
Yeah, so
in May.
yeah, it may be just a matter of a background check or something, as small as that may be pending. But yes, it's a good idea to do. If it is past your processing date, the advance parole or its use should not delay you. That is not the reason for any delay. All right?
And I can travel again also, right? It is not a problem
Yes.
because I'm planning to travel again. Okay.
Yes,
Thank you.
yes.
Thanks, Pallavi.
Okay,
Thanks for
all
your
the best.
All right. Thank you for your call. Once again, 972-361-0606 is the number if you want to get in touch with her in private. Ahluwalialaw.com is the website to go and find out more about them. All right. We are taking your calls all the way till 11:30. 972-235-5555 number in the studio. Go ahead and ask your question, please.
Yes, ma'am. I have a question regarding my green card eligibility. I have my green card which I got in March, and I went back to India in May. I have come back right now, but I want to go back because of my son's education. Is it okay, or will it create a problem?
So you got your green card, and this is through what status? Through an EB category?
I got it through my sister, my husband's sister, actually.
Okay. So EB category. So anytime that you step away from the country, you have to have your re-entry permit if you're going over a year, right? Otherwise, if you keep coming back in and you're here quite often, then it should not be, a major issue. However, if your residence is not based in the US and the government at the port of entry, at the CBP figures that out, they can give you a hard time when you enter the country and you're coming here.
My husband will be here. But I and my son will have to go back to India for his education.
For how long do you anticipate going?
I went in May and came back now, and then again I'll be going in November and coming back by April end or May first week.
Okay, that's fine. I mean, at this time you can do that. Anytime you anticipate that you're going to be out for a while, I would advise a re-entry permit.
Okay.
All right. All the best.
All right. Thank you for your call. Going on to our next caller, Phanisha Radio. You're live on the air. Go ahead and ask your question, please.
Hi. I wanted to know when my husband applies for his green card, will my daughter, who is on F1 visa here, she's from my first marriage, and my husband has not legally adopted her, what would be the process to obtain a green card for her?
Okay, so this depends on whether you got married. So is she under the age of 21 right now?
Yes, she's 18.
She's 18. You got married to your present husband when she was under the age of 18?
Yes.
Okay, so I mean, in that sense, I mean, there could be an analysis that could make him the legal stepfather without the adoption. The adoption doesn't have to happen. This would just be the petition of a step parent. However, we don't know how far his priority date is for me to be able to say whether she will for sure get the green card through him, because that would be that he has to be able to get this before she turns 21. Okay, so but using if the priority date does get current and she's under the age of 21, you can try and file an adjustment of status if it is that the priority date becomes current at any point. All right?
You must be able to apply it in EB1. So
he's applying under EB1. Okay, so that should be even better because that is a current category for India.
Right.
Okay, so you have to be able to show the marriage. Yes, you have to be able to show the marriage certificate that you were married before she turned 18, and that's how he is recognized as a step parent.
Yes, ma'am. Thank you. Thank you very much.
All
right. Thank you so much for your call. 972-235-5555 number in the studio. Going to our next caller, Phanisha Radio. You are live on the air. Go ahead and ask your question.
Hi. Good morning.
Good
I have a
morning.
question. I got my green card last year, November, but my spouse, my wife's green card is not yet received. We took the info pass also, but they are not able to give a proper answer.
Okay, so
What next step I can?
yeah. So what I'm understanding is that you got your green card, but your wife's is still pending.
Yes.
Okay, and it just maybe, and you're in a preference category, which means are you in an EB category?
Yeah, I mean, I was in EB3, then ported to EB2.
Okay.
Then I got, it was the priority date of 2005.
You know, so each person's number is counted against the number that is available. So once in a while, what happens? They try not to do this. They try and keep the families together, and get everybody the green card at the same time. But you may be caught up in the point where you got approved and the numbers got over, right? And that's how they could not give it to your spouse. So now, if the priority date is current for this category yet or not?
Not yet.
Okay.
Probably next month is May.
Yes, so then you have to just wait for the priority date to get current, because there won't be anything that anyone can do till the priority date gets current, and that's when she can
The
get.
priority date is current now, actually, because it's been ported to EB2.
Okay.
Our priority date is 2005 March.
Okay, so just do a letter to the immigration and do this update request, and just bring it to their attention that there is a case, a dependent case on the AOS that is still pending, even with the priority date being current. So then they should be able to process it.
Oh, okay. Just from their website, we have the option to update. Okay.
Yes.
All right.
Thanks for that. Appreciate it.
All right.
Thank you for your call. Going to our next caller, Phanisha Radio. You are live on the air. Go ahead and ask your question. Please, can you turn off your radio before you ask your question? All
Yes,
right.
I'm able to hear me.
Yes, we can. Go ahead.
Yes, wish ma'am to the Pallavi.
Yes, go ahead,
I'm
please.
like,
Go ahead, sir.
hello?
Yeah.
Yes. So the question I have is like, I'm 40 years old and I'm on H1B with I-140 approved.
Okay.
My son is like 12 years old and I'm in EB3 category.
Okay.
So when my son turns down to like 18 or 21, what options should I have if I don't get the green card?
Yeah, so this would cause him to age out if you don't get your green card under that time. If it is an option for you to switch to slightly faster moving category, which is the EB2, then that would be suggested. So the calculation that they do at the time that the visa bulletin shows that your priority date is available and the person has aged out and is not under 21 anymore is the time that they look at to see how long your I-140 was pending. So if your I-140 was pending for, say for example, for 3 years, and his priority date gets current when he's 22, then at that point they will calculate his age as the 22 minus 3, and that would make him eligible. So it is a math that would be done at the time that the priority date gets current, and then they look at his age and also look at how long your I-140 was pending.
Okay, so in that terms, he has the option to just get a student visa here, while when he goes to the college and still stay in the US.
Correct.
Is it true?
Right. So, and my suggestion is to keep him as long as possible on the. So, are you on a dependent? Is he on a dependent visa right now, H4?
Right. Yes.
Okay. Right. So just keep the H1B and H4 going, because then he doesn't have to become an F1 until he ages out and becomes 21.
Okay.
All right.
Okay. Thanks a lot, ma'am. I'll answer the question. Thanks.
Okay. All the best.
Thank you for your call. Moving on to our next caller, Phanisha Radio. You are live on the air. Go ahead and ask your question, please.
Yes, ma'am. My mother has the interview for a green card, but she has a language barrier. So I was wondering, can I go with her as an interpreter, or it has to be like third party?
No, you could go with her. So the green card is coming through what source?
It's a natural. It's a 485 through the family.
Okay, so 485 for the family. So so let's just explore this under the EB category. How are you doing this? How is she getting?
No. As a family, I apply I-130. It got approved. Then I apply 485.
Okay,
and now
I got it.
she's scheduled for interview.
I got it. Yes. So you are the petitioner in this case, right?
Yes, ma'am.
Right. Yes, you can go with her, and you can serve
All right.
as her interpreter, and she has to just confirm whatever's there on her 485. So she'll have to answer them. So just make sure that she understands. If it is that she has no understanding of the language at all, then the 485 should have been signed where there is an interpreter column. That should have also been signed to make sure that she had been explained everything through an interpreter. So, but you can serve that, and if the government wants at the interview, they can have you sign that.
Okay. And also one more question for my father. The same thing for my father. He is also scheduled for interview, but because of the medical emergency, he left the country and without the advance parole. So we know we abandoned the 485, but still I got the letter from the USCIS for the interview. So how should I inform them that the person is not here?
Yeah, so you'll have to just tell them that they're not in the country, and to kind of get this 485 where it has to be removed, because the rule, and you understand that very well, is that if there is an adjustment filed, you can't. He'll have to go through the National Visa Center on this.
Yes, ma'am. Yeah, but whom should I tell that he's not here? Because I called the USCIS and they said, just one time they said write the letter, second time they said just go to the local office with the info pass.
Yeah, and that's fine. You can go to the local office because the interview will be set up in that same office. So you can go there and you can inform them. You can, of course, also write a letter and send it to the address to the same officer that set up the interview. So
thank you so much.
Yeah, and that concerns me sometimes, though, and I'm just making a general statement that the officers don't look at the case before they issue the interview notices, because they're supposed to get the I-94 back if somebody's left. Then they would know that the person is no longer in the country, and they should not be setting up interviews. But I see that sometimes they're not very well informed.
I did apply 824 to transfer the I-130, but I haven't been able to track anything yet. And I called the USCIS office and they said sometimes it happens up to 45 days you cannot track the 824, even though we got the receipt in India.
Okay.
So I'm just waiting for that then.
Surely. So at this time, I think definitely just let the officer know by either a letter or by showing up to InfoPass that your father is no longer in the country. And secondly, ask the officer who's doing the interview, it may be the same person who's doing the interview for mom, as to what would be the fastest way for the NBC to receive notice that he has left and to start off the NBC process.
Got it. All right, perfect. Thank you so much. I really appreciate it.
Okay, all the best.
Okay.
All the best to you. Moving on to our next caller. This is Your Business Matters with Pallavi Ahluwalia from Ahluwalia Law Offices. AhluwaliaLaw.com has all the information. And yes, 972-361-0606 is a number to get an appointment to see Pallavi and her team. Going to our next caller. Panisha Radio, you're live on the air. Go ahead and ask your question, please.
Hi, Pallavi. My name is Pinky, and I applied for my mom's green card when she was here on visitor's visa, and she got her advance parole and everything, and she went to India on her advance parole. Now the last step is for the medical letter that we have to submit from I-693, and we have given us till October 24th to submit the form. Now she is already in India on AP, and I was wondering, is it possible we could delay this so I don't have to have her rushed and come back?
No, unfortunately, there is not going to be a delay in. So this is, you've gotten a request for evidence, correct?
Yes, request for evidence.
Yellow sheet of paper with information requesting for a few things that are missing, which includes the medical that needs to be updated. She'll have to come in, because if you reschedule it, they have an option to deny the case.
So it's better that she comes here and finishes her medical.
Yeah, she should finish the entire process before she travels again.
Okay, got it. Thank you so much.
Yeah, this means that she's close to getting done.
Yeah, so then I'll have to call her back right away then. Okay, thank you.
All the best.
Thank you for your call. 972-235-5555 number in the studio. This is Your Business Matters with Pallavi Ahluwalia. Going to our next caller, Phanisha Radio. You're live on the air. Go ahead and ask your question, please.
Hi, I have a L extension which just got approved.
Okay.
And I also have my green card processed through the same employer.
Okay.
Which is on EB1C, where given the priority dates went back. I'm still waiting for the 485. I have the advance parole and 140 approved like a couple of months back.
All right.
So my company is asking me to necessarily get the L stamping done, and I'm going to Canada for TNC processing. Now my question is, if for any reason the L stamping is not granted, I can still come back to the US on my AP, right?
Correct, you can. Yes, absolutely. So what would be the requirement to use the L if you have the AP that is already approved? That seems to be an extra requirement that you may not need to do, but of course, I mean, not speaking towards the requirement of the company, but legally you don't. So, and for India under EB1C, it is a current category right now in October. So
it's come back to current, okay?
Yeah, it is current right now. So you should be able to get the case approved soon also. So unless you have travel and they require you to be on the L for some other reason, I don't.
Yeah, so what? Yeah, I spoke to the immigration lawyers that the company has, and they're saying that given the 485 is not approved, in the event that there is any problem and approval doesn't happen, then overnight I'll have to leave the country and go back to the home country. So they're advising me to keep my L stamping current.
Okay, so here's a quick question. Did you have your I-140 approved or not?
It is approved already.
Yeah, then I don't anticipate them having any issues. Most of the issues come from the I-140. If there is a concurrent filing of the I-140 and the 485, that is sometimes that causes the issue. The L stamping does seem to be an inconvenient thing, especially when the dates are current. So I differ in my opinion. I would say that the advance parole is ample for you to be able to do everything. You actually didn't need the L if the I-140 was already approved. Of course, you can always have it as a backup, and that may be your option even if you were to have anything that goes wrong with the 485.
Okay, thank you so much.
All the best.
Thank you for your call. Going to our next caller, Fun Asia Radio. You're live on the air. Go ahead and ask your question, please.
My question is, hello?
Yes,
yeah, we can hear.
Actually, my family, that's myself, my spouse, and my child have received the green card in March 2016.
Okay.
And for 5 months, my wife and my son have been to India. From May 2016 to October 2016. Just very recently they came, October 2nd.
Okay.
For 5 months they have been out of USA.
Okay.
And again, they are supposed to go to USA to complete my son's education. That is from November to March end.
Right. I think your spouse also just called about the same question. So I think we did have the same question, exactly the same question with the same dates. But no issue. Of course, I can answer this question too. But if they are coming in and out of the country and it's under 6 months, you can preserve their time for naturalization purposes. They'll, of course, at some point have to be getting their physical presence in the country to be able to be eligible for naturalization later on. Now, any time that you anticipate that they step out of the country for over 6 months or over a year, then do a re-entry permit.
So my question is, within the first year of the immigration status, is going out of USA for 5 months consecutively, and being here only for 1 month in between. So, do a re-entry permit, is it required, ma'am?
No, that's why I said it's only after if they decide to step out of the country for over a year is when it's required. If they're coming in and out of the country, then they should be okay.
It's okay.
Yes.
In the second travel outside US also is not an issue.
Should not be an issue. They may get somebody at the CBP to say, okay, you're not, staying here, or you're not behaving like residents, and that may be a warning that they get, but they really are not outside the country for over a year. It's not just that they're doing a cursory once a year trip into the US. They are coming in and out in under the 6 months.
Yes, because this time when they're going to even get the college admission fees and all that, admission letters and all. So I hope it will not be a problem.
Yeah, I mean, if there is plans for them to stay out and it's going to take them to be out of the country for over a year, then the re-entry permit is merited. Otherwise, if they're coming in and out of the country and they're making frequent trips, they're staying here long enough, like they're here for a few months, then they step out, then it should be okay. CBP, of course, has discretion at any stage. At this point, I don't think you require a re-entry permit, but if there becomes this pattern where they're here only a few weeks a year, then I would say definitely do a re-entry permit.
All right.
It's going to be here for 1 month.
Yeah, the 1 month is fine for right now, sir.
All right. Thank you so much for your call. We have just under 2 minutes left on the clock for the legal segment to end. So do request you to ask your question really quick. You're live on the air. Go ahead.
Yeah, this is regarding my H4 EAD, and I applied for it in December 2015, and I'm yet to receive. And anytime I call the USCIS to check on that, they keep telling me like wait for 30 days, or I get a notice saying you have to wait for 30 days, and now recently I got another notice saying wait for 60 days.
This is for an EAD based on an H4. That is quite ridiculous because they're supposed to adjudicate, and the government is trying to get the adjudication time extended to 180 days from 90 days. But right now, by statute, they're required to give it to you in 90 days. So yeah, and this may be something that you may want to, and there are a bunch of suits that have been filed against the USCIS for not coming through. Though I don't advise that immediately, that remains your option.
Okay, so even if I'm going to call them, I'm not going to have any.
I mean, there shouldn't be no reason for them to say that 30 more days or 60 more days. This is ridiculous. This is something that seems to be misplaced or lost.
It's almost a year for this December.
Yes, and that seems, and you have another option to withdraw this and refile, and that way, I mean, I don't know how long your H4 lasts for, because you may just have shortened your time on the EAD validity by, waiting for this one.
I have my visa until 2018. That's not a problem.
Right. So then you would get 2 more years. And was that the case even when you applied? You had it till 2018?
Yeah, I got it and then applied. So.
Okay, so you do have that time. So yeah, so you could insist on them coming through with the EAD, and you can even write to the district director.
Okay, yes,
right.
Thank you.
All right.
And I like your voice over the phone.
Okay, thank you.
And we love it on air as well. Thank you so much, Pallavi, for coming down to the studio and answering all our, legal questions of our community.
My pleasure, totally. Thank you so much. Appreciate all our calls. Their questions and the answers that follow probably help other people who are just listening. I know I'm out of town.
We all like to win things.